Welcome associates, gather on the stand. This trial's a circus, but I've got a plan. Not a grifter, still worse than Dan. Hopscotch squares, don't trip, don't fall. BK in a felony, I've heard it all. Shake it, magic 8 ball. Tell me the truth, will justice call? Me be the diva, she's running the show. Chief Capone and that, yeah, everybody knows. Fact or fact, well, nobody knows. What the corn echoes as the chaos grows. My credibility left in a vehicle. Hopscotch squares, don't trip, don't fall. BK in a felony, I've heard it all. Shake it, magic 8 ball. Tell me the truth, will justice call? What the corn echoes as the chaos grows. My credibility left in a vehicle.
Ha, I almost started muted, but I didn't. I caught myself. Yay me. What's up, everybody? Happy Monday. I see you, whoever. Hope you had a great weekend. I hear you might get some storms. Or at least some rain. I'm not sure. But you'll like it. What's up, Idol? Hope you are doing well. It's been a great day around here. It is 420. I know some of you celebrate that. I celebrate it because 31 years ago today, my daughter decided that being 10 days late was long enough and was finally born. So I celebrate it because she took me out of my misery. Yeah, that girl. And she's been on her own schedule ever since and doing her own thing ever since then. But wouldn't have it any other way. So, but I was miserable. And people did not want to be around me. I don't blame them. So that's the only thing that I wish they would have done is I wish they would have she was born at 4:18 in the morning. Could they not have just changed it and just fudged it 2 minutes? So she'd been born at 4:20 on 4:20. Like, come on. What's up, Snipe? How are you doing? Hope you guys all did something fun over the weekend. I spent all weekend with Miss Madison. And I think I found that she has an on-off switch. Oh, I'm sorry, Heidel. Yeah. It's 60 right now, but it was chilly. We were chilly yesterday. Madison is only supposed to have her pacifier when she's getting ready to go to sleep, but if she sees it, she just like hones in on that thing, and she will do whatever to get it. So she had it, and I was going to take it from her because she was going to go play. So anytime I went to take it from her, she'd lay her head down on my lap like, I'm so tired. So then I would let go of it, and she'd get up like, okay, I'm going to go play it. So I'd take it again. And she played this game. Well, she would not take a nap, and she was sitting in my lap. And so I was like, if you're going to play, I got to take this away from you. And again, she lays her head down. And so we do this back and forth a little bit. So finally, she's like sliding down the chair. She's standing on the floor. Her feet are on the floor. And so I bring her back up to my lap, and I take the pacifier from her, and she literally just falls over and just doesn't move. I was like, what the heck are you doing? She was out like a light. I found the off switch. I don't know where it was. I found it. I don't want to take a nap, Bobby. You take a nap. But I found it. And then She woke up and she just was kind of laying around. She wasn't really moving. She just on my lap, just like, whatever. And I picked her up because I wanted to take her and give her dinner. And as soon as I picked her up, I apparently hit the on switch because she was awake. And I mean, it was like, holy crap, like, did somebody just inject you with sugar? Because you are awake. But oh my, she was so funny. Well, thanks, Zach. I know you don't like the blonde, but it's okay. You're with your new family now, and I have zero hopes you're ever going to find that exit. Oh, goodness. Like cleaning around the power cables. Yeah, it's on and it's off. Got to, and sometimes you got to plug it right back in because you've unplugged it accidentally and you can't figure out why. Well, I mean, just to be, she'll be 2 at the end of June, but to just to be able to sit there and know, like, I'm gonna take this from you because you're supposed to only have it when you're sleeping. And she's like, okay, I'm tired. I know, but you've already told me you don't like the blonde, so that was a genuine, heartfelt. I know you have a new family now. Just kidding, Zach. It's all right. It'll be okay. Thank you for the compliment that my hair looks decent. What's up, Bad Dazzer? How are you? Yeah, we didn't think she was going to take that. We thought she was actually going to be a thumbsucker. And then she was like, nope. One day she's just like, yeah, I'll take best fare. Yep, no Gabby on Mondays. Generally. Sometimes she surprises me. And I don't know what Bree's doing. I don't know what you did deserve such blessings. Maybe next Monday when you come back, my hair will be dark. It won't be, but maybe. You can just hope. Hang on to that hope. This is it, because grace. So that's the way it is. All right, we are in the final days of this trial. Finally, we're finishing it up tomorrow. Bree's probably sharpening her teeth. Hey, Bree has nice choppers, so that's all I can say. She's got nice. She has pretty teeth. I'm gonna bore you for probably a minute. Well, like 28 of them. I don't generally do this, but we are going to listen to jury instructions on this trial because I think they are important and I think they're going to play into the verdict. They are. It is highlights, but it will just get blonde. More blonde over the summer. I know I do, Zach. It's fine. It's fine. I'm not doing gray streaks yet. I can't do it, Bobby. I can't. I can't. Don't do it. So we will listen to the jury instructions. If they get too repetitive, then maybe we'll stop them. But it's 28 minutes. We can do it, right? And then we will go into the state's closing. Tomorrow we'll do the defense closing, rebuttal, and the verdict. I do not want to be a wizard. I really don't. What's up, Shenny? I think we do need to see what the jury instructions are in this. I do know, and I'm not going to share it now, I do know there was part of this that the attorneys were not allowed to discuss in front of the jury. So we'll get into that after we finish everything up. You got lots of gray night. You're allowed to. You're a man. I'm not allowed to. Wizard Borpy? What are you typing, Bobby? You can't wait to go gray, but your mother was 82 and only had a couple of gray hairs. Lucky her. You could call me Gandalf. I don't want to be called that. I don't. What? There's no way Shinny blocked you, Zach. No way. She's gonna say something in just a minute. Shinny's a wizard or something. Yeah, but Shinny has pretty hair. I can't pull that one off. Can't do it. All right, let's get this torturous part over, shall we? So we can, I'm ready to wrap this thing up. I'm just ready. It's been a short, but the longest trial. What's up, Noel? You all blocked Zach? Well, that wasn't very nice. See, Shinny did not block you. She said, I don't do shit. That's what she said. So if you can't see her, I don't know. I can't help you. I know, Nidawau. All right, let's do it, shall we? Make sure I don't have it muted. And we get to see the judge. We've not really seen much of the judge. Yeah, Shinny, he said he can't see you. And he asked if you blocked him. And I said, no way. You can't see that? Oh, well, tell Shinny I said hi. All right, I told her. Are you in live chat, Zach? That's what Idol wants to know. Go out and come back in. You know, the old turn it off, turn it back on.
Ladies and gentlemen of the jury, we will be going through the jury instructions at this time. I've provided one for every other person in an attempt to save some paper. Please read along with me. Don't read ahead. Don't fall behind. Just turn the pages when I do and keep up with my reading. You will have a copy of this also during deliberations, so this is not the last time you will see this. This is the State of Iowa versus Dixie Shanahan. The trial information charges the defendant with the crime of murder in the first degree. The state alleges that in August 2002, the defendant Dixie Shanahan caused the death of Scott Shanahan willfully, deliberately, and with premeditation and malice aforethought. The charge includes the lesser included charges of murder in the second degree, voluntary manslaughter, involuntary manslaughter by public offense, involuntary manslaughter by conduct likely to cause death, willful injury, assault with intent to commit serious injury, assault causing serious injury, and assault. Dixie Shanahan has pleaded not guilty to the charges, and she claims that she acted in justification, self-defense, or defense of another. Instruction number 1. The trial information is the document that formally charges the defendant with a crime and is merely the method by which the defendant is brought into court for trial. It is not evidence. Number 2, the defendant has entered a plea of not guilty. The plea of not guilty is a complete denial of the charges and places the burden on the state to prove guilt beyond a reasonable doubt. Whenever I instruct you the state must prove something, it must be by evidence beyond a reasonable doubt. If the state does not prove the defendant guilty beyond a reasonable doubt, your verdict must be not guilty. Number 3, the defendant is presumed innocent and not guilty. This presumption of innocence requires you to put aside all suspicion which might arise from the arrest, charge, or the present situation of the defendant. The presumption of innocence remains with the defendant throughout the trial unless the evidence establishes guilt beyond a reasonable doubt. Number 4, you must determine the defendant's guilt or innocence from the evidence and the law in these instructions. You must consider all of the instructions together. No one instruction includes all of the applicable law. Number 5, the duty of the jury is to determine if the defendant is guilty or not guilty. In the event of a guilty verdict, you have nothing to do with punishment. Instruction number 6, nothing I have said or done during the trial was intended to give any opinion as to the facts, proof, or what your verdict should be. Number 7, you shall base your verdict only upon the evidence and these instructions. Evidence is, number 1, testimony in person or by deposition. Number 2, exhibits received by the court. You may examine the exhibits closely, but be careful not to alter or destroy them. Number 3, stipulations, which are agreements between the attorneys. Facts may be proved by direct evidence, circumstantial evidence, or a combination of both. Sometimes during a trial, references are made to pretrial statements and reports, witnesses' depositions, or other miscellaneous items. Only those things formally offered and received by the court are available to you during your deliberations. Documents or items read from or referred to which were not offered and received in evidence are not available to you. The following are not evidence. Number 1, statements, arguments, questions, and comments by the lawyers. Number 2, objections and rulings on objections. Number 3, any testimony I told you to disregard. Number 4, anything you saw or heard about this case outside the courtroom. Number 8, in considering the evidence, make deductions and reach conclusions according to reason and common sense. Facts may be proved by direct evidence, circumstantial evidence, or both. Direct evidence is evidence from a witness who claims actual knowledge of a fact, such as an eyewitness. Circumstantial evidence is evidence about a chain of facts, which show a defendant is guilty or not guilty. The law makes no distinction between direct evidence and circumstantial evidence. Give all the evidence the weight and value you think it is entitled to receive. Number 9. Decide the facts from evidence. Consider the evidence using your observations, common sense, and experience. Try to reconcile any conflicts in the evidence, but if you cannot, accept the evidence you find more believable. In determining the facts, you may have to decide what testimony you believe. You may believe all, part, or none of any witness's testimony. There are many factors which you may consider in deciding what testimony to believe. For example, number 1, whether the testimony is reasonable and consistent with other evidence you believe. Number 2, whether a witness has made inconsistent statements. Number 3, the witness's appearance, conduct, age, intelligence, memory, and knowledge of the facts. Number 4, the witness's interest in the trial, their motive, candor, bias, and prejudice. Number 10, you have heard testimony from persons described as experts. Persons who have become experts in a field because of their education and experience may give their opinion on matters in that field and the reasons for their opinions. Consider expert testimony just like any other testimony. You may accept it or reject it. You may give it as much weight as you think it deserves, considering the witness's education and experience, the reasons given for the opinion, and all the other evidence in the case. Number 11. The burden is on the state to prove defendant guilty beyond a reasonable doubt. A reasonable doubt is one that fairly and naturally arises from the evidence or lack of evidence produced by the state. If, after a full and fair consideration of all of the evidence, you are firmly convinced of the defendant's guilt, then you have no reasonable doubt and you should find the defendant guilty. But if, after a full and fair consideration of all of the evidence or lack of evidence produced by the state, you are not firmly convinced of the defendant's guilt, then you have a reasonable doubt and you should find the defendant not guilty. Number 12. If there is a reasonable doubt as to the degree of the crime, the defendant shall only be convicted of the degree for which there is no reasonable doubt. Number 13. To commit a crime, a person must intend to do an act which is against the law. While it is not necessary that a person knows the act is against the law, it is necessary that the person was aware he was doing the act and he did it voluntarily, not by mistake or accident. You may, but are not required to infer a person intends the natural results of his acts. Number 14. A dangerous weapon is any device or instrument designed primarily for use in inflicting death or injury, and when used in its designed manner is capable of inflicting death. It is also any sort of instrument or device which is actually used in such a way as to indicate the user intended to inflict death or serious injury, and when so used is capable of inflicting death. Number 15. The state must prove all of the following elements of murder in the first degree. Number 1, on or about August of 2002, the defendant shot Scott Shanahan, and 2, Scott Shanahan died as a result of being shot, and 3, the defendant acted with malice aforethought, and 4, the defendant acted without justification, and 5, the defendant acted willfully, deliberately, premeditatedly, and with a specific intent to kill Scott Shanahan. If the state has proved all of the elements, the defendant is guilty of murder in the first degree. If the state has failed to prove any one of the elements, the defendant is not guilty of murder in the first degree, and you will then consider the charge of murder in the second degree as explained in instruction number 21. Instruction 16. Willful means intentional or by fixed design or purpose and not accidental. To deliberate is to weigh in one's mind, to consider, to contemplate, or to reflect. Premeditate is to think or ponder upon a matter before acting. Malice is a state of mind which leads one to intentionally do a wrongful act to the injury of another out of actual hatred or with an evil or unlawful purpose. It may be established by evidence of actual hatred or by proof of a deliberate or fixed intent to do injury. It may be found from the acts and conduct of the defendant and the means used in doing the wrongful and injurious acts. Malice requires only such deliberation that would make a person appreciate and understand the nature of the act and its consequences, as distinguished from an act done in the heat of passion. Malice aforethought is a fixed purpose or design to do some physical harm to another which exists before the act is committed. It does not have to exist for any particular length of time. Number 17. If a person has the opportunity to deliberate and uses a dangerous weapon against another resulting in death, you may, but are not required to, infer that the weapon was used with malice, premeditation, and specific intent to kill. Number 18, malice aforethought may be inferred from the defendant's use of a dangerous weapon. Number 19, concerning element number 2 of instructions 15, 21, and 23, the wound inflicted by the defendant resulted in the death of Scott Shanahan if it caused or directly contributed to Scott Shanahan's death. Number 20, deliberation and premeditation need not exist for any particular length of time before the act. Number 21, the state must prove all of the following elements of murder in the second degree. Number 1, on or about August 2002, the defendant shot Scott Shanahan, and 2, Scott Shanahan died as a result of being shot, and 3, the defendant acted with malice aforethought, and 4, the defendant acted without justification. If the state has proved all of the elements, the defendant is guilty of murder in the second degree. If the state has failed to prove any one of the elements, the defendant is not guilty of murder in the second degree, and you will then consider the charge of voluntary manslaughter as explained in instruction number 23. Ma'am, do you need some water?
Yeah, it might help.
Could one of you get her some water, please? Instruction number 22. Murder in the second degree does not require a specific intent to kill another person. Number 23. The state must prove all of the following elements of voluntary manslaughter. Number 1, on or about August of 2002, the defendant intentionally shot Scott Shanahan, and 2, Scott Shanahan died as a result of being shot, and 3, the shooting was done solely by reason of sudden, violent, and irresistible passion resulting from serious provocation, and 4, the defendant acted without justification. If the state has proved all of the elements, the defendant is guilty of voluntary manslaughter. If the state has failed to prove any one of the elements, the defendant is not guilty of voluntary manslaughter, and you will then consider the charge of involuntary manslaughter by public offense, as explained in instruction number 25. Number 24. Concerning element number 3 of instruction number 23, a serious provocation is conduct that would cause a reasonable person to have a sudden, violent, and irresistible passion. Passion is not sudden, violent, and irresistible if there is an interval of time during which a reasonable person would, under the circumstances, have time to reflect and bring her passion under control and suppress the impulse to kill. Words alone, however abusive or insulting, cannot be serious provocation. Number 25, the state must prove all of the following elements of involuntary manslaughter by commission of a public offense. 1, on or about August 2002, the defendant recklessly committed the crime of assault. And 2, when the defendant committed the act, the defendant unintentionally caused the death of Scott Shanahan. And 3, the defendant acted without justification. If the state has proved all of the elements, the defendant is guilty of involuntary manslaughter by public offense. If the state has failed to prove each of the elements, the defendant is not guilty of involuntary manslaughter by public offense, and you will then consider the charge of involuntary manslaughter by conduct likely to cause death as explained in instruction number 26. Number 27. A person is reckless or acts recklessly. There is no 26. Do you have a 26? Something happened to my 26. Must have got. All right. Instruction number 26. If you recall, the previous instruction 25 referred then to 26. Number 26, the state must prove all of the following elements of involuntary manslaughter by conduct likely to cause death. Number 1, on or about August 2002, the defendant recklessly discharged a weapon pointed at Scott Shanahan. 2, the defendant did the act in a manner likely to cause death. 3, by doing the act, the defendant unintentionally caused the death of Scott Shanahan. 4, without justification. If the state has proved all of the elements, the defendant is guilty of involuntary manslaughter by conduct likely to cause death. If the state has failed to prove any one of the elements, the defendant is not guilty of involuntary manslaughter by conduct likely to cause death, and you will then consider the charge of willful injury explained in instruction number 28. Number 27. A person is reckless or acts recklessly when she willfully disregards the safety of persons or property. It is more than a lack of reasonable care which may cause unintentional injury. Recklessness is conduct which is consciously done with willful disregard of the consequences. For recklessness to exist, the act must be highly dangerous. In addition, the danger must be so obvious that the actor knows or should reasonably foresee that harm will more likely than not result from the act. Though recklessness is willful, it is not intentional in the sense that harm is intended to result. Number 28. The state must prove all of the following elements of willful injury. Number 1, on or about August 2002, the defendant shot Scott Shanahan, and 2, the defendant specifically intended to cause a serious injury to Scott Shanahan, and 3, Scott Shanahan sustained a serious injury, and 4, the defendant acted without justification. If you find the state has proved all of the elements, the defendant is guilty of willful injury. If the state has proved only elements 1, 3, and 4, the defendant is guilty of assault causing serious injury. If the state has proved only elements 1, 2, and 4, the defendant is guilty of assault with intent to inflict serious injury. If the state has proved elements 1 and 4, but failed to prove elements 2 and 3, the defendant is guilty of assault. If the state has failed to prove elements 1 and 4, the defendant is not guilty. Number 29. Specific intent means not only being aware of doing an act and doing it voluntarily, but in addition, doing it with a specific purpose in mind. Because determining the defendant's specific intent requires you to decide what she was thinking when an act was done, it is seldom capable of direct proof. Therefore, you should consider the facts and circumstances surrounding the act to determine the defendant's specific intent. You may, but are not required to infer a person intends the natural results of her acts. Number 30, concerning element 2 and 3 of instruction number 28, serious injury means a bodily injury which creates a substantial risk of death or causes protracted loss or impairment of the function of any bodily member or organ. Number 31, bodily injury means physical pain, illness, or any impairment of physical condition. Number 32, the defendant claims she acted with justification. A person may use reasonable force to prevent injury to a person, including the defendant. The use of this force is known as justification. Reasonable force is only the amount of force a reasonable person would find necessary to use under the circumstances to prevent an injury. To prevent death or injury. A person can use deadly force against another if it is reasonable to believe that such force is necessary to avoid injury or risk to one's life or safety, or the life or safety of another, or it is reasonable to believe that such force is necessary to resist a like force or threat. The state must prove the defendant was not acting with justification. Number 33. A person is justified in using reasonable force if she reasonably believes the force is necessary to defend herself from any imminent use of unlawful force. If the state has proved any one of the following elements, the defendant was not justified. Number 1, the defendant started or continued the incident which resulted in injury. Number 2, an alternative course of action was available to the defendant. Number 3, the defendant did not believe she was in imminent danger of death or injury, and the use of force was not necessary to save her. 4, the defendant did not have reasonable grounds for the belief. 5, the force used by the defendant was unreasonable. Instruction number 34. Concerning element 3 and 4 of instruction 33, the defendant was not required to act with perfect judgment. However, she was required to act with the care and caution a reasonable person would have used under the circumstances which existed at that time. If in the defendant's mind the danger was actual, real, imminent, or unavoidable, even though it did not exist, that is sufficient if a reasonable person would have seen it in the same light. Number 35. Concerning element number 3 of instruction number 33, the defendant claims danger existed. You are to consider the danger or apparent danger from the viewpoint of a reasonable person under the circumstances which existed at that time. It is not necessary that there was actual danger, but the defendant must have acted in an honest and sincere belief that the danger actually existed. Apparent danger, with knowledge that no real danger existed, is no excuse for using force. Number 36. Concerning element number 2 of instruction number 33, if a defendant is confronted with the use of unlawful force against her, she is required to avoid the confrontation by seeking an alternative course of action before she is justified in repelling the force used against her. However, there is an exception. If the defendant was in her own home or property, which she was legally occupying, and the alternative course of action was such that she reasonably believed she had to retreat or leave her position to avoid the confrontation, then she was not required to do so, and she could repel force with reasonable force. If the alternative course of action involved risk to her or another's safety, and she reasonably believed that, then she was not required to take or use the alternative course of action to avoid the confrontation, and she could repel the force with reasonable force, including deadly force. Number 37. If you find that before the incident, Scott Shanahan made threats against the defendant, and because of this, the defendant had reasonable cause for believing she was in imminent danger of death, you may consider the evidence of the threats in determining whether the defendant acted reasonably when she fired the shot in question. Number 38. Evidence has been received concerning Scott Shanahan's acts of violence against defendant and another, and character for being violent in an effort to show that Scott Shanahan was a dangerous and violent person. This evidence bears on whether Scott Shanahan was the aggressor at the time the defendant fired the shot, and also whether the defendant acted under circumstances which would have caused a reasonable person to be afraid of being injured or killed by Scott Shanahan. A deliberate and unprovoked use of force was not justified merely if Scott Shanahan was a dangerous and violent person. If the defendant used force in revenge or only to punish Scott Shanahan, the defendant's act was not justified. Number 39. The term deadly force means 1. Force used to cause a bodily injury which creates a substantial risk of death. 2. Force the defendant knows or should reasonably know will create a strong probability that serious injury will result. 3. Discharging a firearm in the direction of someone knowing they are present, even though there is no intent to cause a serious injury. Number 40. If you find the defendant guilty, you must decide if she was armed with a firearm. To be armed means the defendant had a firearm on her person at the time of the crime. It is not necessary the firearm was used, displayed, or represented as being in her possession. The state must prove beyond a reasonable doubt the defendant was armed with a firearm. You shall answer the question about this issue, which is attached to these instructions. Your answer, as with the verdict, must be unanimous. Number 41. You have heard evidence claiming the witnesses made statements before the trial which were inconsistent with what the witnesses said in this trial. Because the witnesses did not make the earlier statements under oath, you may use them only to help you decide if you believe the witnesses. Decide if the earlier statements of the witnesses were made and whether they were inconsistent with testimony given. You may disregard all or any part of the testimony if you find the statements were made and they were inconsistent with the testimony given, but you are not required to do so. However, you should not disregard the testimony if other believable evidence supports it, or if for some other reason you believe it. Number 42. You have heard evidence claiming certain witnesses made statements before this trial while under oath, which were inconsistent with what the witnesses said in this trial. If you find these statements were made and were inconsistent, then you may consider them as part of the evidence, just as if they had been made in this trial. You may also use these statements to help you decide if you believe the witnesses. You may disregard all or any part of the testimony if you find the statements were made and were inconsistent with the testimony given at trial, but you are not required to do so. Do not disregard the trial testimony if other evidence you believe supports it, or you believe it for any other reason. Number 43. Evidence has been offered to show defendant made statements at an earlier time and place while not under oath. These statements are called admissions. You may consider an admission for any purpose. Number 44. During the trial, you have been allowed to take notes. You may take these with you to the jury room to use in your deliberations. Remember, these are notes and not evidence. Generally, they reflect the recollection or impressions of the evidence as viewed by the person taking them and may be inaccurate or incomplete. Upon reaching a verdict, leave the notes in the jury room and they will be destroyed. We're going to skip 45 for now, so go to 46. I am giving you 10 verdict forms. You shall use only one of the 9 of the 10, obviously. Verdict, you shall use only one of the 10 following verdict forms. When you have agreed unanimously upon a verdict and the foreperson has signed the verdict form, please notify the court attendant. Dated today and signed by me. Now I'm going to go through the verdict. It's on the next page. These are the forms of the verdict, the 10 forms that have been given to you, plus a special interrogatory that was mentioned during the instructions. Number 1, form of verdict. We find the defendant guilty of murder in the first degree. If that is not your finding, you consider number 2. We find the defendant guilty of murder in the second degree. If that is not your finding, you consider number 3. We find the defendant guilty of voluntary manslaughter. If that is not your finding, you consider number 4. We find the defendant guilty of involuntary manslaughter by public offense. The next verdict form is number 5. We find the defendant guilty of manslaughter by conduct likely to cause death. Number 6, we find the defendant guilty of willful injury. Number 7, we find the defendant guilty of assault with intent to commit serious injury. Number 8, we find the defendant guilty of assault causing serious injury. Number 9, we find the defendant guilty of assault. As you will see, there is a signature line for the foreperson on each one of those verdict forms. And as the form said at the beginning, you may only use one of them. On form number 10 is we find the defendant not guilty, and similarly there's a signature line for that. And then following that, in the event there is any finding of guilt, you must answer the special interrogatory. If your finding is not guilty, then you do not need to answer the special interrogatory. And I think if you read those instructions, you will find that all to be self-explanatory, and each one of those verdicts, as you read through the instructions, has appropriate instructions that go with them. At this time, the attorneys will be making a final argument, and some...
All right, well, I just learned something. I would have to read the jury instructions. I can't sit and listen to stuff like that and then I can't process it that way. I have to see it. I have to be able to read it and see it, and then when I am done listening to whatever you're saying, I need to be able to go back over it again myself. Oh, sorry, Judge. I feel like you're looking at me like, okay. But so she was charged with first degree, and then there were all the lesser included. And I was trying to get, I kept up till the willful injury, and then all the assault ones, I was done. I couldn't keep up anymore. So there's first degree, second degree, there's there's manslaughter, involuntary manslaughter, there's another voluntary manslaughter, but I couldn't catch the end of it, willful injury, and then all the other ones that were assault. There's a lot of options. Yeah. And that is what you call, when the cards are stacked against you, all those guilty pages and one not guilty page. Yeah. I don't like lesser included. Most of the time, sometimes they work out, but most of the time, if I just want the state to charge you with what they think they can get, what they think you did. We would not do good on a jury. Well, they have the instructions to take back with them. I would have to do that. Sitting there just listening to somebody go on and on and on, my mind started wandering, and I was paying attention to chat, and so I was like, I'm kind of lost. And he went through the charges so fast, I didn't get them the first time, and I didn't get them all the second time. Yeah, I think I would have to. It's like, in a Bueller voice at that. They couldn't take notes then. I think juries should always be allowed to take notes. I've never understood why people don't allow jurors to take notes. That's me, Bad Dazzler. And I start overthinking it, And then I start questioning myself. Did I remember that correctly? I need to, I gotta see it to be confident in what I think they said. See, if I read them to the juror, each one would have its own personality. I might retain it better that way. I'm not gonna lie to you about that. That might actually work better for me. Let me get the state up here. I have a feeling, well, I'm going to say he's probably going to irritate us because he always irritates us. But he didn't irritate us as bad when he cross-examined Dixie as I thought he was going to. So maybe we'll be okay. I don't know, Snipe. I don't know. I promise nothing. That's why you have your teaching down. Well, I just, doesn't Indiana allow jury questions and aren't they allowed to take notes? It does. They allow jury questions in Delphi. I don't know if all judges do it. I don't know how that rule works. And I don't know how the notes rule works. Control Alt. You want to know the one thing I remember about Control Alt Tab? The way you were telling me to put my fingers on the keyboard, I couldn't do it, so I had to use both hands. In her defense, the pew pew only went off because he stepped on a bee. Maybe. Might be onto something, Ash. For lesser included charges, it would be really helpful if they made a grid showing which things comprise each level of the charge so that they could decide which elements they believed and act on that. That's a good idea. I've done one. I did one. Flashman. It was a sad one. It was an infant. A mom caused the death of her infant. And it was a bench trial. And she got off because the state charged her wrong. And the judge didn't have any other option. He had to release her. It was really sad. And it was really maddening. Because she had, I don't know why she did this. She had 2 other kids. She took the older kids back into her bedroom to watch TV, but she left this tiny infant, and I forget if it was 2 months old or less, and propped a bottle up and fell asleep. And they don't know if the baby, if it was because she had propped the bottle or if it had rolled over and suffocated. It was horrible. It was awful. So, I have no idea. I'll just tell you, I hope she didn't have any more kids. Yeah, I mean, the judge had to do what the judge had to do. That's the state. It's on the state. But you blew your chance. Can't try her again. Men have to learn to type one-handed. Fat dasser. I think, I mean, you can't leave a baby, you just can't leave an infant alone for as long as what she did. You just can't, and you can't, don't prop a bottle. Like, don't do that, and then especially leave it. Like, that's just all sorts of bad things waiting to happen. Okay, you guys ready? Hey, what's up, Sharon? What's your what, Ash? It was an Indianapolis case. You're just going to have to go, I've done it, flash me. I've done it. Yeah, that part was ridiculous, but I can see why the time was long. Yeah, she should have just put her, she should have just, I don't know why she left her out there. That was the thing. Like, why'd you leave, of all the people, you left the most defenseless one on the couch. The one that couldn't help herself at all. It was bad. Way back in the olden days, yeah, like 2 years ago. I don't remember when I did it. YouTube's being mean to you again. I'm sorry, Ash. Okay. Well, it's probably, let's get this out of the way. I don't know what's going to happen here, but let's see. Let's see. Don't throw anything, okay? I'll try to do the same.
Final arguments are not evidence in a case. You've heard all the evidence.
Holy
Final
crap.
arguments are not the law in the
S's.
case. I've given you the law that you must follow. The attorneys will mention the facts and the evidence. They will mention these instructions, as they should do. And they will not try to mislead you. They're going to be telling you what they believe their case has shown. It's an extremely important part of the trial for the attorneys to go through this with you. We ask that you give them your attention, and that's all for now. So, Mr. Toman.
Here we go.
Didn't want to forget you. Please, the court.
Yes.
Ladies and gentlemen of the jury, as the court just described to you, this is the time for the closing arguments. I'll be allowed to argue to you what the evidence has shown, argue to you what your verdict should be. The defense attorney will do the same, and we'll try to do this persuasively, but we'll also try to do it with the idea in mind that you've had a lot of time to listen to the evidence as well, and you'll be making the final decision. Before I say anything else, though, I want to say something I'm sure no one will argue with, and that's simply that on behalf of myself, and I'm sure the defense, the court, all of us connected with the case, we appreciate the time and attention you've given us here in the courtroom, and the patience that we know we've asked you to exercise when you're back in the jury room. A couple of times we've had a little bit of delays. We're not trying to inconvenience you, and we appreciate your cooperation. Now, the judge has just read to you the instructions, and I was looking back. It was Tuesday of last week that we began this whole process, and it was at that time that I think most of you were fairly new to this, and not had much, if any, jury experience, and you learned that there would be instructions in the court and that there would be evidence. And now you've heard the instructions of the court, and remember how much importance we attach to those instructions and your ability to follow those instructions. I think you can see now what we're driving at. Now those instructions, I know you just, they've almost been kind of dumped in your lap this morning in a way, but the judge has taken some time to read them to you thoroughly. You'll have a full opportunity to study those. And I know it may seem daunting to you right now. You heard a lot of legal terms. You heard a lot of various things, various offenses. And right now you may be a little concerned about where do we go from here. Once we work through these instructions this morning, once you have a chance to see how they work within this case in your deliberations, I think you'll find that they really are what they're supposed to be. They're a roadmap to help you reach your verdict in this case. A couple of them I'd like to highlight for you because we did talk about them during the jury selection. One was it was instruction number 5, and if you want to turn to it, you can. I think I can summarize it for you pretty quick. It's simply the instruction that tells you what your duty is in this case. The duty of the jury is to determine if the defendant is guilty or not guilty. In the event of a guilty verdict, you have nothing to do with punishment. And I bring that up to you just to point out to you that, as we talked about during jury instruction, that is here, and it's something that you should feel comfortable with. That's your only duty, simply determine the defendant's guilt in this case. You don't have to go any further, consider any other issues in this case. Anything like that would be up to the court. Another instruction we talked about early on was how much proof. Now the burden is on the state. I have to prove this defendant guilty beyond a reasonable doubt. How much proof do I have to present to you? Well, instruction number 11 tells you that I have to present proof beyond a reasonable doubt. And as we heard the judge describe it, as we talked about during jury selection, if you look at this instruction, you'll find really in that third paragraph that the real gist of it. If it says, if after a full and fair consideration of all the evidence, you are firmly convinced of the defendant's guilt, then you have no reasonable doubt. So that's essentially what we're talking. That's the amount of proof we need. It's not beyond every hyper-technical, imagined doubt. It's merely a proof to the point where you're firmly convinced of the guilt of the defendant. Nothing more, but nothing less. So instruction number 11, if you're wondering what is beyond a reasonable doubt, there it is for you. It means you're firmly convinced. Now there's a number of other instructions that I'll be talking about and I'll direct your attention to. You heard terms like malice aforethought, dangerous weapon, those kinds of things. Those are all defined. And of course, the defense in this case is justification or self-defense. And you heard some instructions on that. We'll talk about those. All of these instructions are important, but to my mind, and I would submit to you, perhaps one of the key instructions, and really the starting point for your deliberations in this case is number 15. If you want to take a look at that, that is the instruction number 15, that tells you what I have to prove in this case, what the state of Iowa, the people here in Shelby County have to prove in this case in order for you to find the defendant guilty of murder in the first degree. And just like we spoke about during jury selection, there's 5 things there. 1, 2, 3, 4, 5. As I mentioned to you back then, it depends on how the judge breaks them down. It could be 4, it could be 6. Well, the way he's presented those to you here in these instructions, 5 things. And what I'd like to do is, in a moment, go through each one of those line by line, 1, 2, 3, 4, 5. Look at the evidence and see what evidence there is to show that this defendant is guilty of that crime charge, the crime of murder in the first degree. Before I do that, I think you may have seen something, and the judge did a very good job of explaining the process we go through here. Remember when he showed you those jury verdict forms at the end of the case? You start with, in this case, murder in the first degree. Now, in Iowa, we have what's called the lesser included offense theory or doctrine, which means there are lesser included offenses that sometimes are necessarily committed when a person commits a higher offense. But in this case, as the judge told you in those forms of verdict and as in instructions, we start with murder in the first degree. Consider that. Now, there are some offenses, some of these lesser included offenses don't even deal with death. You'll see there's 2 or 3, maybe 4 of them that deal just with an assault. Well, Scott Shanahan died in this case, but the judge is required by law to submit to you all lesser included offenses. I'm going to focus on the main charge, because that's where we start, and if there is enough evidence to show this defendant guilty of the main charge of murder in the first degree, and I submit to you that there is, then, and you find that in your deliberations, you stop right there. The foreperson of your jury signs that. We, the jury, find the defendant guilty of murder in the first degree, and the case is over. You don't, if you find the defendant guilty of the main charge, you don't consider those lesser offenses. So with those things in mind, let's turn to instruction number 15 and take a look at these 5 elements. The first element is pretty straightforward, that on or about August of 2002, the defendant shot Scott Shanahan. What evidence is there of that? Well, there seems to be plenty of evidence, obviously. If we had nothing more, we do have the missing persons investigation that was conducted by the Shelby County Sheriff's Office. They went out, they tried to find Scott, who had apparently dropped off the face of the earth. They couldn't find him. Ultimately, a search warrant was obtained. The address, the Shanahan residence, where the defendant and Scott Shanahan lived, was searched, 203 3rd Avenue in Defiance, and we know that his body, ultimately identified his body, was found in the northeast bedroom. We know that Paul Bush and the investigators that discovered the body found an injury to the back of his head that was apparently a gunshot wound, as we found out from Dr. Gooden. We know that the only adult in that house other than Scott Shanahan was this defendant. And we know from the testimony that she admitted to 2 other people that she had, in fact, shot Scott Shanahan. She told her friend Kathy Myers that day while the search was going on, they're going to find him. I shot him. She told Monica Tetzloff in a little bit more detail. Remember, Monica was the prisoner, the woman with the drug record. She was obviously no angel. But when you're in jail, that's the kind of people that are in jail, people that have done things wrong. Monica Tetzloff had a criminal record, there's no doubt about it. You had a chance to listen to her, evaluate her testimony. She told us things that she could not have made up. She told us things that she could not have invented, particularly the loading of the gun, that the gun was loaded with 2 different shells. Monica told us that and she told Deputy Hervey that back in October 30th. The gun wasn't even found until January 15th of this year. So we know that was credible evidence, and we know that this defendant told her, yes, I shot him in the back of the head while he was lying in the bed. And finally, ladies and gentlemen, the defense really has conceded this. I don't think they tell us it's no mystery that they're saying it's self-defense. Yes, the defendant shot Scott Shanahan. They do claim that she acted in self-defense. So if we look at that, number 1 of Instruction 15, on or about August 2002, the defendant shot Scott Shanahan. Has that been proved beyond a reasonable doubt? Yes, it has. Plenty of proof. Number 2, that Scott Shanahan died as a result of being shot. Anytime there's a questioned death, anytime there's a death under suspicious circumstances in the state of Iowa, an autopsy is performed by the state medical examiner's office. That was done here. The body that they ultimately identified as Scott's was taken to Des Moines. She performed a post-mortem examination, and we know that Scott sustained a shotgun blast to the back of the head. Remember, Dr. Gooden recovered a piece of plastic from the hair. That was part of the shot cup, or the plastic wadding, I guess is the proper terminology. That was part of a shotgun shell. She also recovered from inside his skull the main part of that plastic wadding. It's in that one photograph, a pretty large piece of plastic that had actually been blasted into Scott's head. She recovered several pellets, and we also, I think, Exhibit 55 during your deliberations, you'll see is a photograph of an X-ray of the skull of Scott that shows a very wide dispersal of pellets, shotgun pellets in there, along with the fractures. The blast broke every bone in his head in one way or the other. So it was the Dr. Gooden concluded just from an examination without even having the gun available that was a shotgun blast to the back of the head. And Vic Murillo, the firearms expert, back in November and October, when he looked at just those pieces of ammunition, could tell that it was a 20 gauge. Later on, when the gun was recovered, we know that it was a 20 gauge shell fired from a 16 gauge shotgun with a 12 gauge live round still in the magazine jammed in there. So has the state proved element number 2, that Scott Shanahan died as a result of being shot? Yes, and I imagine the defense will concede that as well. The third one seems a little bit more of a lawyer thing, doesn't it? It says the defendant acted with malice aforethought. And yet that is a legal term, no question about it. And I think the court has provided you with a pretty good definition. In fact, the exact definition of what malice aforethought is. Now, it's found in instruction number 16, which deals with a lot of different definitions. The part that I'm calling your attention to now is where it starts off, malice is a state of mind, and it goes from there down to the edge of the page. And as you look at that now, and as you look at that during your deliberations, I think I can distill this for you. Distill this down to simply malice, malice is a fixed purpose to do some harm to somebody. I think you'll find at that bottom sentence, malice aforethought is a fixed purpose or design to do some physical harm to another which exists before the act is committed. Now, there's an important addition there, that final sentence. It does not have to exist for any particular length of time. All All right, so it's a fixed purpose to do some harm to another. It's a mental state. It'd be nice if I could bring in an x-ray and say, look at this x-ray of this person's head and we can see exactly what they're thinking. We can't do that, obviously. But the law recognizes that mental states can be difficult to prove directly from positive evidence. And so the law will tell you that you can infer malice. You can conclude that somebody acted with malice under certain circumstances. Let me show you what I'm talking about. Instruction number 18. It's a very short, very succinct instruction, but it says malice aforethought may be inferred from the defendant's use of a dangerous weapon. That's just common sense, really. If somebody takes a dangerous weapon, points it at another person, pulls the trigger, meaning to shoot them in the head, isn't that a fixed purpose to do some harm to another? Isn't that malice aforethought? Yes, it is. The law allows you to infer that just from the use of the dangerous weapon. It's just common sense. You point a gun at somebody at the back of their head, you fire that gun into the head. Do you have a fixed purpose to do some harm to another? Of course you do. Of course you do. So if we had nothing more than just the use of the shotgun here, you would have more than sufficient evidence to conclude that element number 3, that the defendant acted with malice aforethought, that has been proven. The use of a shotgun in and of itself is enough. There's something more, though, that we know in this case, just beyond the fact that a shotgun was used. We know that the defendant knew the gun was loaded. She conceded that in her testimony. She knew the gun was loaded. I think her words were, on cross-examination, I pulled the trigger. I meant it to go off. I hoped it would go off. And you meant for it to go off so it would hit him in the back of the head and kill him. Yes. So we actually do know what was on the defendant's mind. We don't just have to infer it from the fact that she used a shotgun. Her own words told us that, yes, I meant to shoot him in the back of the head and kill him. That's a fixed purpose to do some harm to another. That's malice aforethought. Let me turn then to number 4. That's instruction number 15, item 4. This is that the defendant acted without justification. Now, this is the fighting issue in the case, as I've seen this case unfold. It seems to me that this is what the defendant is definitely going to focus on. She was justified in what she did. That being the case, I'm going to hold off. I'd like to put that aside. We'll return to that in just a moment or two, but let's take a look at number 5 then and see where we're at on that number 5. Now, number 5 says, let me pull it out here myself. I know it's kind of a mouthful. The defendant acted willfully, deliberately, premeditatedly, and with a specific intent to kill Scott Shanahan. A lot of things in there, a lot of things. What do all those things mean? We can go back to instruction number 16. And follow me here if you would, because it's really pretty easy. It's not as difficult as it seems. Instruction 16 was, did she act willfully? Willful means by intentional or fixed design or purpose, not accidental. There's no claim in this case that when she pulled the trigger was an accident. She said she meant to shoot him. She said she meant to kill him from the witness stand, and she did. Was this a willful act? Sure, it was not accidental. So we know that she acted willfully. Now, here's 2 other terms here: to deliberate and premeditate. To deliberate is to weigh in one's mind, to consider or contemplate or reflect. Premeditate means to think or ponder about a matter before acting. What kind of thinking are we talking about here? Now, you remember the defense lawyer in his opening statement, he made a comment something like, well, would you shoot somebody and then leave them in the bed for 15 months? What kind of planning, that can't be premeditated murder. Well, that's kind of a misstatement of what we're dealing with here. We're not talking about criminal masterminds who carefully, this is not an Agatha Christie novel where someone carefully plans out a crime from beginning to end and some super sleuth has to solve it. We're dealing with real life and human beings. This instruction doesn't say she had to act with foresight. She had to think things all the way through. It merely says she had to deliberate, to think, to ponder. Now, where do we go with that? There's two ways, there's two pieces of evidence that tell you that that has been satisfied. First, instruction number 17. What this says is, if a person has an opportunity to deliberate and uses a dangerous weapon in death, you may, but you're not required to infer that the person or the weapon was used with malice, premeditation, and specific intent to kill. In other words, if someone uses a firearm to kill someone, you can infer that they premeditated that act, that they had an intent to kill. That's only common sense, again. If this was a heat of passion situation, if someone was struggling for a gun, we're not talking about this situation, but that's not the case at all. There was no struggle for any firearm here. In fact, think about the facts in this case, ladies and gentlemen, because that's really what tells you that we do have a willfulness, a deliberateness, and premeditation. By the way, the instructions will tell you that these don't have to exist for any length of time. Instruction 20, deliberation and premeditation need not exist for any length of time. In other words, someone doesn't have to think about killing another for 30 minutes or 20 minutes or 10 minutes, 5 minutes, 90 seconds, a minute. All a person has to do is think, I'm going to kill that other person. I know what I'm doing. I'm going to kill that other person, and then acts. That's premeditation. That's acting with deliberateness. Do we have any evidence that this defendant did that? And remember, we're not talking about planning a crime from start to finish and acting with foresight. You won't see anywhere in those instructions that I have to prove that this defendant sat down and from A to Z planned out how she was going to commit the crime and how she was going to dispose of the body. Obviously, the disposal of the body, she left it in the bed and hid it there. Is that good judgment? Is that the best way to handle the disposal of a body? I wouldn't think so at all. Does that mean she didn't commit murder in the first degree? Not at all. It's not a question of foresight and planning. It's a question of thinking and then acting. What evidence do we have of that? She says, the defendant says there was an argument that morning. She says that she describes Scott Shanahan beating her on the stomach. She describes Scott Shanahan pulling out a shotgun. And then she tells us that the fight, the confrontation, whatever it was, stopped. He took the shotgun and went in the bedroom. She sat down in that chair. As I understand it, it was this blue chair right here that you see in the monitor. And this blue chair, that's in the living room. It's right about there, if you can see where I'm pointing on the diagram. You can see the doorway through to the kitchen. Here's the blue chair. And on the diagram, it would be right about in that area. What did she do? She sat there. Scott went in the bedroom. He laid down in the bed. She sat there. Now, her son was at school. Ashley had gone to a friend's house about a block and a half away. She's the only one in the house. And she sat there in that chair thinking. She told us that. Mulling over what was going on here. And then she said, and this gave her a full opportunity to deliberate, to realize, to think about what she was doing. And then what did she do? This man she described as being in this horrible rage, who she was so terrified of, who was armed with a shotgun. She says that she got up from the blue chair, and then she walked down the hall and into the bedroom to where he was. To where he was. Why would she do that? Well, her story was that she had to go to the phone. But she didn't even know if that phone in the bedroom worked. She knew Scott Shanahan was in there, if we believe that scenario she's painted. And she goes in there into the lion's den because she had to use the phone, when all she had to do, ladies and gentlemen, all she had to do was walk right out that door, go get her daughter, Ashley, if she was really that afraid of her life and really felt that endangered, and call the sheriff. Every time the sheriff was called, they would come. They take these things seriously. They don't, it's not a thing where, oh, we'll be there in about an hour and a half. It's not a fender bender where the officer, if he's busy, he may not show up at the scene. These are serious situations. That's all she had to do. But she went into that bedroom. She thought about it. She deliberated on it, premeditated, thought what she was going to do, and she went into the bedroom. By the way, remember she said that that Scott had taken the car keys. So, of course, she wasn't able to drive away in a car. Although we know that Scott was wearing underwear. That's all he had on. No car keys in the bed. No car keys ever found in the bedroom. The defendant didn't seem to have any problem at all getting in the car and driving up to the No Frills grocery store a little bit later that day, writing a bad check.
I gotta take a break from him. I have to take a break from him. I'm so sorry. He's just ticking me off. Because all I keep thinking of is all the dumb questions he asked her on cross-examination of when she said, he was repeatedly hitting him in the stomach. Well, your baby was born and it was okay, wasn't it? Okay. So that says he wasn't? He wasn't hitting you because your baby was okay? I can't. He is giving a boring closing. I can tell you, I haven't listened to most of it. I'll just be honest with you. But every time I do start to listen, then he starts to tick me off. Me too. He is like, but did you die? No, I didn't. He did. Not all attorneys from Iowa talk this slow. No, the next one, the defense attorney, he can at least hold my attention. This guy just, oh my gosh. Yeah, they don't unalive you until they do. And then it's too late. Yeah, oh my gosh. Send away, Flash Fan, send away. I'll take it. All right, I just needed a break. Also, if she was, I get the whole premeditated kind of thing. I get that. I don't like that it can be premeditated by, seconds. If she did have the crap beat out of her that morning, if he did threaten to take her life by the end of the day, was she thinking clearly? Probably not. Clearly she wasn't thinking clearly, because if she had planned this out for more than 5 seconds, she would have thought, well, what am I going to do with you afterwards? I'll just leave you there in my bedroom for a year and a half. Be fine. Don't worry about it. 2 little air fresheners. Perfect. Oh my gosh. Oh, and also I went to the grocery store and I wrote a bad check, probably for something that she needed. What's up, Iris? I don't like to make plans because the word premeditated gets thrown around. Good thinking. Good thinking. I mean, it's just, oh yes, yes, Ronnie, the towel. Yeah, I forgot. She put the towel under the door too. That all kept the smell away. All of it. It was fine. Not even a candle, like we thought it was, because she told us that was one of those air fresheners that has the little holes in the top. So, you know, they work great. Maybe she made Febreze. I don't remember when Febreze came out. Because, you know, I was thinking all clear and I went to the store and I wrote a bad check. You know, it was the no frills grocery store at that. Didn't even buy anything fancy. Iris, you're flying to Ireland on Wednesday. We'll have a safe trip, and I can't wait till you get back and hear all about it. Ireland's not going to know what hit them. I love it. I love it. Don't go to jail, though. Please. Oh my gosh. Like you should just live stream that. You should just you walking around Ireland. I did not. I did not commit check fraud. Yeah, writing a bad check is more of a failure to do math. All right, well, if you want to go to jail, you go to jail. That's fine. I will not ruin your fun. And Jess is raising bail money if needed. So we'll get you. We will get you. We'll get you out. It'll be great. And then maybe like a leprechaun can be your defense attorney. Sorry. Bad joke. How else are you going to meet so tall, handsome, and copper? I don't know. I don't know. Maybe he'll be a jailer. Right? Europe doesn't put people in jail as easily or as for long or for as long. I've heard their jails are nicer than ours too. That's not hard. Our jails are pretty bad. We did watch Leprechaun in the Hood recently, so good joke, KJ. I've actually... Yep, that is horrible. That is a bad show. You have to laugh at it. All right. Okay, I think my brain can take more of his just droning. And poor Scott, poor Scott, such a good guy. Nobody even cared he was gone. Yeah. His family wasn't looking for him. It's great. It's great. Don't worry about it.
Writing a bad check and claiming that Scott was still alive, signing his name. The car keys. He was wearing underwear, ladies and gentlemen.
Good for him. What's up, Gabby?
If you look at this instruction, did the defendant act willfully? In other words, did she act not accidentally, but meaning to shoot Scott? Yes, she did. Did she act deliberately? Did she have a chance to think about her options, to weigh? While she sat in that blue chair, she certainly did. Did she have a chance to think about the matter further, premeditate it? Yes, she did. She went into that bedroom, went to where the shotgun was, and she tells us there was a movement. There was a movement. But we know that Scott Shanahan didn't move at all after she shot him, that she shot him as he was lying, and that was in the back of the head. And we know that when you shoot a firearm into the back of someone's head, under the law, you're acting with a specific intent to kill. If you know the consequences, you're acting with a specific intent to kill. So the state has proved element number 5, that she acted without an accident, acted willfully. She acted with having had a chance to think what was going on here, acted premeditatedly, and went ahead and did it. So the question is, 1, 2, 3, and 5 have been proved. The question is, did she act with justification? There's seems to me to be three general areas of facts that come into play here in this justification area. One is, without a question, the domestic abuse by Scott Shanahan on this defendant. As I told you from day one, he was not an easy guy to like, and I think that has absolutely been proved here. Did he commit domestic abuse on this woman? Absolutely he did. Was what he did wrong? Absolutely. I'm a criminal prosecutor. I prosecute people for doing what he did to this defendant. That's part of my job. Did he do something wrong? Absolutely. Is there any way to excuse it or minimize it? No, I can't do that, and I wouldn't do that. This woman was a victim of domestic abuse without a question. The real question is did that domestic abuse play any role in the death of Scott Shanahan, any direct role? Now, the defense, as I understand the evidence that they're presenting, especially with that one, the director of the coalition, Ms. Schipper, they painted a picture as if this domestic abuse situation is just a hopeless situation, and that the only way out of this in any circumstance would have been what happened here. This was the only way for this defendant to get out. Remember, the defendant's attorney in his opening statement told you this is not a case about choices. This is a case about the fact that she had no choice. She had no choice but to do what she did to Scott Shanahan. So the evidence that they've presented, and I think they want to suggest to you, shows a crescendo of violence, just a growing situation of violence that just ultimately and inevitably resulted in the death of Scott Shanahan, and that's just not true. It's just not true. You heard the testimony of Susan Christensen. There are plenty of women that suffer this problem on a daily basis, week in, week out. She said every 9 days they have to obtain protective orders. There are plenty of women that deal with this issue. Some have more success than others. But she showed that, yeah, there is a way out. This is not an inevitable process that is always going to result in the battered woman, the abused woman, having to kill her abuser. It's just not inevitable. Her testimony showed that. And I think your own common sense tells you that. And here's another thing. Do not misunderstand what I'm saying. I'm not going to, if it sounds like I'm trying to say what Scott Shanahan did to this defendant was not serious, if it sounds like I'm trying to say it was not a wrong thing or a crime, that's not what I'm saying. What I want to say at this point, though, is this. Luckily, thankfully, she did not sustain any serious permanent injuries. I know she sustained a chipped tooth. We heard about that yesterday. That's especially for a woman. I know it's a defacing injury, and there's no way that Scott Shanahan should ever be excused for doing that. But really, luckily, ladies and gentlemen, no broken bones. No extended hospital stays. In fact, I think the only time that this defendant was in the hospital for something that Scott had done was when, remember, Chief Deputy Hervey took her. You'll see it in that one exhibit. I think it's 46. She had a black eye, and then her left eye had some blood in the iris, and it's a really nasty looking injury to me. Thankfully, it was not a permanent or a serious injury. She was treated at the hospital and released.
Okay. So you gotta have broken bones? My gosh. What? Stop. Stop talking, dude. Well, if she just had some broken bones, yeah, and she only went one time, I mean, how bad could he be? I know he was horrible, but Never caught. She just didn't do anything right. She did all the wrong stuff by not reporting it, by trying to get the charges dropped when it did get reported. And heaven forbid she went to the hospital. Or didn't go to the hospital, because, I mean, I'm sure he would have been just fine with that. How dare she? That's right. I can't. Going to the hospital would probably lead him to being worse. Yep, when she got home, exactly. I would be so mad if I was sitting there as a juror right now. I would be furious at this guy. It is rude, Gabby. It is so rude. I mean, just if he could just experience it for just a bit on how it is, he probably wouldn't say such stupid things. This is ridiculous. I bet she put too much mayo on his sandwiches too. Off with her head. Probably right. Probably right. You can't forgive that. I mean, what was she thinking? How dare she not be exactly what society think a victim should be? True, whoever. True. Oh my gosh. Well, you are so right, Bad Dazzer. We do not want to be wasting hospital time on such minor things. I mean, he just poked her in the eye. It's no big deal. It was only bleeding. No big deal. No big deal. Not the mayo. I just, I can't. I can't. All right. I'm just pointing that out. I just don't point it out, sir. How about that? She did. She forgot the cheese on his grilled cheese. That reminds you need to get mayo. I'm glad we could help. So glad. All right. I will try. I'm trying to make it through this because I just want him to stop talking.
Am I trying to say what Scott did was right? No. I'm just pointing out that there is, at least as violent as he was, the degree of the violence never reached the degree of violence that was directed against him by this defendant. It never reached that point. Thank God. I'm not excusing what he did. But I think you need to consider that. Think about the pattern of conduct that we have here. Doesn't it seem like most of the violence occurred from the 1990s up until about 2000 when the defendant went to Texas? We heard, I think, 17 defense witnesses yesterday. Some were obviously, and I understand, some of them had some strong opinions about it. You remember the one woman who said that the defendant's jaw had been broken, and I understand. She wanted to make sure that you understood that this was a serious abusive situation, and we do understand that. You do understand that. I understand.
Oops.
Look at the facts and not allow ourselves to take sides.
Sorry. I'm sorry. I'm so sorry. Okay. I sped him up just a touch because sometimes people have a hard time when I speed it up too much. They have a hard time understanding. I don't know what I did after that. I don't know. I just want him to stop talking, so I just took him down. Thanks. It's like, okay, bye now. All right. I can do that too. I think I can speed this up 1600%. And I've done that just to make Gabby laugh. I'm just, oh my gosh. Thank you. I'm glad you love it here and not hate it here, Bobby. Thanks, whoever. Okay. Here we go. Here we go.
In the case. And I understand some of those witnesses felt a little bit that way. That's perfectly natural. These were people that could support this defendant. Another reason why this was not inevitable. We saw 17 people here who came in. They were behind her yesterday. There are social services available in this county. There's the sheriff's office. There's the county attorney's office. There's a battered woman shelter here in this area. I think the shelter is not necessarily here in this town, but it's available to women in this town. Plenty of services available. Plenty of help. Plenty of help here. No. And it seems like the domestic violence after about 2001, the April of 2001, from what I heard in this evidence, there were no more reports of domestic violence of a serious nature. The defendant never called the sheriff's office. None of her friends ever did. None of her friends, as I recall, or her acquaintances reported any obvious evidence of abuse. Was there abuse going on? The defendant says there is, and given Scott's pattern, I'm sure there was. But was it a continuing rising thing to a point, a rising crescendo to the point where this is how the case had to end? No. It didn't have to end this way. Did domestic abuse play a role in this? Yes. And there's other things that played a role here as well. The defendant admitted on the stand that she did resent Scott. And I would think it's only natural for her to resent the abuse that he inflicted on her. I think she had some resentment because he was not a man that held a job hardly at all. He was living off that inheritance, and that was slowly dwindling. And finally did dwindle down to zero in the summer of 2002, just about a month or so before this event happened here. So there's that happening too. There's a lot of pressures involved in this situation. But for the defense to suggest to you that this area of fact, that this domestic abuse, right there, that is the excuse for what she did to Scott Shanahan, it's just not borne out by the facts in this case. What other areas are there that speak to the issue of justification? What are factual areas? There's what she did after she shot Scott. Now, if a person acts in self-defense, if a person believes, I've just had to kill someone because my life was threatened, because he said he was going to abort my unborn child, and therefore I had to kill him. He just pulled out clumps of hair. They were laying in the garage. He had beat me. I had obvious signs of beating that anyone could see. What's a person that sincerely acted with justification in self-defense going to do at that point? They're going to call the police. They're going to call the sheriff's department. They're going to report it. They're going to open themselves up and say, I had to do it. Come in here, investigate this. Look at my hair on the floor. Look at these bruises on my face. You know how this has been for me the last 10 years. I had to do it. Here's the gun. Take the gun away. Get it out of here. That's what a person that has really acted with justification is going to do. Is that what this defendant did? No. She engaged in a pattern of deception, an active concealment of her crime. This prevents us from really fully examining the scene. She says she put the gun in the kid's closet right away. We'll never know. She says hair was pulled out of her head. We'll never know. She says she has sustained bruising and injuries from Scott's beating that day, August 30th of 2002. We'll never know. Because she didn't do what a person that had acted with justification would have done. She didn't report it. That's all she would have had to do. But she engaged in this pattern of deception, isn't it? Do you see this almost without missing a beat? Later that day, she drives up to the No Frills and starts writing checks on that account. She knows the account's down. And in fact, within a couple of weeks, she knows the account is bouncing checks, and she continues to write checks. She's writing checks. I think they totaled about $2,000 by October 9th or so, just about that. Always signing Scott's checks. When the merchants received those bad checks and wrote and said, hey, we want these checks made good, she would write back saying, well, I'm sorry, Scott's not living here anymore. You'll have to get a hold of him. He's down in Atlantic. She went ahead and just sold off every asset that he had, converting that to money. What'd she do with the money? She took that money, $10,400 worth of money that she converted by selling Scott's cars and his snowmobiles and his tools and all those things, and she sent it down to her sister in Texas. Why? To hide it so she could get ADC. Just a pattern of deception. And this is not someone who's naive. She knows exactly what she's doing, writing checks, blaming somebody who's dead, directing the merchant. She knows she can't be arrested because Scott Shanahan's the one that signed the check. She's hiding assets from the government so she can receive welfare. Then she has her sister send back and make the house payments for her. Are those the actions of someone who has acted with justification and is not guilty of committing a criminal offense in this case, in the death of Scott Shanahan? I think the last set of facts that speak to the issue of justification is exactly how the shooting occurred in this case. Remember, she said she sat in that chair, the blue chair, you can see on the monitor here. I don't think anybody asked her exactly how long, but it was clear that she sat in there for some time before she stood up and went into the bedroom. Now, she says that she had to go into the bedroom to reach the phone, and I submit to you that that's just not right. If that's all she was concerned about, the welfare, the safety of herself and her unborn child, then the only thing that she would have done at that point is leave. Because Scott's in the other room. Why would you go right into the room that he's in? Then she says, and then she says, this is the doorway to the bedroom. So the chair's over here. She walks down the hall into the bedroom, and Scott is lying in the bed right here. She admits that he's lying on his side, facing this way. And if he was awake, because he's lying in that direction, he would have seen her come right through that bedroom door. She says she went over to get the phone, and there was the gun. She says that she was reaching for the phone. There was some kind of movement. She picked up the gun, pointed it at him, and shot and killed him. She insists, ladies and gentlemen, that Scott Shanahan was alive and awake at the time she shot him. Well, he was alive, but he was sleeping. When you get back in the jury room, you'll have a full chance to really see this picture. Try to get it focused as well as I can.
This might be his body again, just warning.
Members of the jury, the man is sleeping. Just, what is it? A picture is worth 1,000 words. I know it's a cliche, but sometimes the reason things are cliches is because they tend to be true. And in this case, you can see from that picture the man is sleeping. He's got a pillow right between his legs. He's wrapped his arm around another pillow in this fashion. And he's not just laying on his side like this, he's actually over like this, with his right shoulder is pointed more towards the edge of the bed. She shot him in the back of the head while he was sleeping. Those are important facts for you to consider, obviously, in determining whether she acted with justification. The loading of the gun. She says she saw him load it. We know from the evidence that this man, Scott Shanahan, had a lot of guns. I think one witness yesterday, that young lady that saw the guns lined up in the one room that back in 2000, before Scott, not even sure whether, I guess that was before Scott had been ordered to turn over his guns, but she even said, what, 20 or 30, maybe that was a little overstatement, but we know he had a lot of guns. He was a gun person. This gun, this 16 gauge gun, Exhibit 36, you'll have it in the jury room, was a 16 gauge shotgun. The defendant admits, yeah, I don't know the difference between the gauges. Well, there's nobody, and you can say that he was in a rage. He was in such a rage when he loaded the gun that 10 minutes later he went in and laid down and went back to sleep. But you can say, as she wants to, that he loaded it in a rage, and that's why that ammunition is loaded in there improperly. But who's going to load a shotgun and not realize they have the right ammunition for it? Someone who doesn't really know shotguns. A 20 gauge shell into the chamber, 12 gauge shell jammed into the tube magazine there. That 12 gauge that was a live round, by the way. She knows. She told you, I knew that there were 2 shells in that gun. I knew it was loaded. She fired it, so she knows there's 1 shot. Now, if this is a loaded gun that she really didn't look at after she fired that first shot, or that she hadn't really given any attention to, if she had a loaded gun, what's she going to do with it? She's going to take it and put it in her children's bedroom? A gun that she believed could go off? Any mother's going to do that? I mean, this gun, her lawyers put a trigger lock on it when they found out that it was in there a year and a half later. Or not a year, excuse me. Well, I guess it was there a year and a half later, but when they found out about it after she'd been charged in the case, it had been in there for a year and a half in her children's bedroom. Why would any mother leave a loaded shotgun where 6 and 5-year-old kids are? A room that they occupy, they play in. You can see the photographs. There's toys in there. There's stuff all over, just like kids' rooms are. The answer is pretty obvious. She knew that gun at that point wouldn't fire anymore. She's the one that had loaded it. She realized that that second live round was jammed, that it wouldn't come out of that tube. She knew that remember the ejector's broken, you open the bolt, and it wouldn't kick out the spent shell. Remember how Mr. Morello had to take a rod and push out that spent shell? She knew that gun wasn't a danger to her children because she loaded it. She's the one that put it in the children's bedroom, and she left it there. So what do all these facts mean? The domestic abuse and her pattern of deception and the actual facts regarding how Scott Shanahan died. Oh, by the way, remember I called the criminalist back, Mr. Bush, and asked him about this distance here. This distance from this wall right here to the bed, he measured exactly 4 feet. And he estimated, he didn't measure the distance from the edge of the bed here to where Scott's body was. But looking at the photograph, he approximated 12 inches. So we're talking 5 feet away. Scott Shanahan is sleeping 5 feet away when this defendant claims she had to grab the shotgun and shoot him in the back of the head in self-defense. You can't accept that evidence, ladies and gentlemen.
I thought they came back with a different number and that guy never measured that the last day of testimony when they recalled that guy. The first guy said it was like 5 feet or 6 feet away. I thought this last guy that they recalled that he's talking about said a different number and then said he didn't measure that. And also, how does he know that she knew that firearm would fire again? How does he know that she knew that? Maybe she knew nothing about that. She just happened to just put in whatever she thought was going to work because she didn't know the difference. And one came out. They did, Shenny. They absolutely guesstimated stuff as evidence. It was ridiculous. It's ridiculous. What do you do? Ugh. She never said that she knew there was a live round in there. I don't remember her saying that. But he's testifying. He's saying it as she did. She had to get to it before him, and that only means she had less time because she had less space. Yeah, and that firearm is what they say that thing was. Did they say that thing was like 52 inches? That thing's long. I know, guys. I don't remember. Did they say that thing was 52 inches long? This seems really long. But, so, okay, if that thing's 4 feet long, and she's at 5 feet, he had nothing on him that, to me, that's close. Maybe that's not close enough to put any stippling on it. Stop it. Okay. That seems about right. All right. I can't do math. I'm not doing the math. But it just seems like that's pretty close range of not having stippling on him or any of him on the weapon. I know I'm the one doing it. I think she already had it in her hand. I think, yes. And he was like, I think that. I think she went in to call. I think he had a movement, as this guy is saying. And she jumped and she fired. That's all I don't think he was facing her when she fired. I think he was laying in bed. Just his position, he looks like he was just laying there. Like that. Yeah, no, I'm thinking, like, yeah, she had it because she wanted to use the phone. He can stop making the argument of why she didn't go out the front door. She didn't. She just didn't. He'd already dragged her back in the house that day, so why would she think she could? Okay, and also his whole thing about, well, if she didn't think she was guilty, why wouldn't she call the police? She had unalived somebody. You may not think you're guilty, but that is going to mess with your head, especially when you are already not thinking clearly. And she'd already been through it for 20 years. She knew they weren't going to take him. And she would probably call her repeatedly asking for the charges to be dismissed. It is frustrating. It's just a revolving door there, and she's part of it. I'm not blaming her. But why would she call them again? Like, it's not going to work. She knows what she's going to have to do because the pressure's well, I guess he wouldn't be there to put the pressure on her this time, but true. How do you trust the police when they can't do squat about anything? True. Or even if they arrest him and they just let him out anyway. Even if she hadn't asked. All it would have done is gotten her where she is now a little over a year earlier. Yep. She was pregnant. She had kids. She didn't want to leave them, have a baby in prison, or them to lose both parents. True. I don't think he is missing the whole her mind is screwed up from a lifetime of abuse. Yeah, I don't know. She was already freaked fuck out from what he did earlier and had it in her hand because she was petrified just in case he came after her while she used the phone. He shifted and she knee-jerk responded. I think that's what happened. What's up, John Gary? How you doing? She regularly left the house to go to work to support his lazy butt, and she moved to Texas multiple times. She got fed up and unalived him in his sleep. I think she did unalive. I think she did do it while he was sleeping. I just don't know if it was because she meant to or if he moved and she jumped. And then she didn't know what to do. Clearly, very reasonable people can have a hard time understanding her mindset because it does defy logic. Thing is that we humans aren't as logical as we wish we were. You think he is missing the whole, I got it. Her mind is screwed up from being a lifetime of abuse. Sorry, Snipe. I also think she just thought she could ignore it and pretend it didn't happen. Trauma does weird stuff to people. Absolutely it does. The case is about this day, though, not about past days. Did she believe that she was trapped on this day? Apparently she did. I don't know. Like, none of us can get into her mind to know exactly what she was thinking. We will never know exactly what happened because we weren't there. And from personal experience, your life becomes such a tiny bubble you can't possibly be worried about the outside world at all. You're focused on the issue at hand. Absolutely. Especially in a high-stress situation when you don't know what's around the corner. How come you're... Oh, there it is. I was like, all right, John Gary, how come your comments not coming up? I don't believe any of her story about what happened that day. I believe most of her stories of abuse, but not one bit about what happened that day. I think something happened that day. Well, obviously something happened that day, but I think some, I don't know. I don't know. When in the midst of that kind of abuse, rational thought is more than likely not going to happen. True. Yeah, we're supposed to focus on mitigating the immediate harm in an emergency, life-threatening situation. No one thinks rationally under the influence of strong emotions. True. The weird thing is sometimes it isn't even a big thing that tips someone over the edge. It's just the straw that breaks the camel's back. Absolutely. Like, I mean, it was a joke about the mayo, but it could be something so simple. And she did leave. And then he would start his love bombing, for lack of a better term. And come back. She did drop the... I know she did all of those things. For whatever reason, who knew the time when she was going to leave and that was going to be the time that she stayed gone? This is how defenses let DV victims down. If I can be brutally honest, the days that I snapped, I knew not of me snapping, nor of what was going on as I either walked over and stopped breath or broke teeth. I just wasn't in attendance. I think, Shani, that's horrifying and I'm sorry. But I understand what you are saying. You just don't. You're just not there. You're trying to make it to tomorrow, and your decisions are based on trying to survive long enough to get there. There's a lot of trained behaviors based on abusers' routine. Absolutely. Yeah, and your mind can lead you to think things that other people wouldn't understand because a person's mind leads them down that road, and you have to have been down that road with her mind. It's what happens with abused people. Of course, he'd show back up, love bomb, but how do you know he didn't threaten her family because even they couldn't keep him away? Yep. And he went to Texas to bring her back. I mean, I don't know. It's a mess. It's just a mess. All right. We're almost finished, which is good because I need to be.
There is obviously, as I said, some law on justification self-defense, and the judge read it to you. I'd like to highlight a couple of things. Instruction number 32. It refers to what reasonable force is. You can use reasonable force, and it's the amount of force that a reasonable person would find necessary under the circumstances to prevent death. Well, there's no force being used against the defendant, Dixie Shanahan, at the time she took up that shotgun. The guy was lying in bed. It's not as if he was coming at her with a weapon and she had a weapon and she had to shoot first. Only the amount of force a reasonable person would find necessary under the circumstances to prevent injury or death. There were no circumstances there would require her to use force. Stand up from that blue chair, 10 steps to the front door, dressed, clothes on, shoes on. Go get Ashley. Get out. Call the sheriff. Instruction number 33 actually tells you that if any one of these five things are true, and they're listed 1, 2, 3, 4, 5. If any one of those 5 things have been proved, then the defendant did not act in self-defense, did not act with justification. I think you'll see, I'm not going to take you through each one of these 5 at this point. You'll have a chance to read it, but let me highlight, for example, number 2. If the defendant had an alternate course of action available to her, she was not permitted under the law to use that shotgun in self-defense. She can't claim it's not self-defense if that's the truth. Instruction 36 tells you what an alternate course of action is. And I'm going to summarize it for you a little bit, and obviously if I don't read it as properly as you think it should be, you'll have a chance to do that too. But it basically says if you have an alternate course of action available to you, you have to take that course of action. Now there's an exception. If you're in your home, and she was, and you're confronted with force then nobody's going to expect you to have to take an alternate course of action. And the law says you don't have to if you're in your home and you're confronted. But that's the key word. Look at that where it says if the defendant was in her own home or property, which she was legally occupying, and an alternative course of action was such that she reasonably believed she had to retreat or leave her position to avoid the confrontation. There was no confrontation. The confrontation, even by her testimony, had ended. Scott had gone back to bed. She was sitting in the blue chair. There was no confrontation. She did have an alternate course of action, and she was required to take that. And simply, ma'am, if you're afraid for yourself, just leave. Walk out that door. Don't go back in the bedroom where he's at. Unless you're going back in there, not to act in self-defense, but because you've had it, you've resented this man, you've had a chance to consider it, you know there's a weapon in the house, and you decided to take some action. And that's what happened here. Another element you'll see throughout Instruction 33 is, did the defendant have reasonable grounds to believe her life was in danger? Did she have reasonable grounds to believe that she had to use this kind of force? Was the force used by her reasonable? Under no circumstance can that be the case here. He's lying in bed. He was in another room. He's lying in bed and he's asleep. It's not reasonable to go in and shoot someone in the back of the head and claim that you acted in self-defense under these circumstances. Did Scott Shanahan abuse this defendant? Yes, he did. Was he abusing her at the time that she shot him in the back of the head? He was lying in bed sleeping. She didn't act with justification. So if we look at those 5 elements in instruction 15, 1, 2, 3, 4, 5, if the state has proved all of those beyond a reasonable doubt, 1, that Scott Shanahan was shot by the defendant on August of 2000. 2, Scott Shanahan died as a result of being shot. Yes. The defendant acted with malice of forethought. We described that, a fixed purpose to do some harm. The defendant acted without justification. We've looked at that and seen that there was no justification here in this case. And finally, that the defendant acted willfully. That means not by accident. Deliberately, that means with some intention, premeditatedly, with a chance to think about what was going to happen. Didn't have to be a long period of time, but a chance to think, and she had that sitting in that chair, and with a specific intent to kill. We have proof of that beyond a reasonable doubt. So for these reasons, ladies and gentlemen, the state has proved its case to you that this defendant is guilty of the main crime of murder in the first degree. And I'm going to ask you at the conclusion of this case to find this defendant guilty as charged with a crime of murder in the first degree.
All right, now I can take it down. Oh my gosh, shut up. All right, good news is his rebuttal is only 16 minutes, okay? That's tomorrow. So we will get a break from him. I need one. Snipe, I didn't get your, I'm sorry, I didn't get your comment approved in time. Where'd you go? Where'd you go, Mr. Snipe? If you could have whacked Hitler while he slept in 1940, would you? I'm not muted. I watched a show one time that sent people back to off Hitler when he was an infant, and they couldn't do it. Made you think. Because it's a baby. And you know what's going to happen, but it's a baby. It's a baby. Be hard. So I don't know. I know this guy's just doing his job, and I'm trying to remember that. I'm just trying to remember that. But I can't remember the name of it. I cannot remember the name of it. I just remember them getting there and seeing the baby and was like, ooh, maybe not. No, but I would have let him study art. Why do they go to when he was a baby and not when he was in World War I? I don't know. I think it was to make you think. The Man in the High Castle? I don't know. I don't know what that is. Is that the name of the show? I thought it was some time traveling show. Shani, I don't remember if they did or not. I just remember that part of it. Like, it was amazing. That part stuck with me. I don't know why. You already poked a hole in the logic. Fine. The Man in the High Castle. Look at you, Flash fan. All right. So tomorrow, I might be hangry. I'm just warning you guys because I cannot eat tomorrow. So I'm glad the longer part of listening to this guy was today, because I may have, I don't know, you might have just saw me throw my computer or something and the screen go black. I don't know. But tomorrow we have the defense closing, which should not be as hard to listen to. One, that guy just is better. He's just a better speaker, in my opinion. You're going to talk smack about my pencils tomorrow? I wouldn't do that if I was you. I'm just kidding. I cannot. I will not be able to eat till Wednesday sometime when I wake up. But anyway, it should be a crime. That's why I'm not you. Fine. Yeah, they always pick on old Hitler, but they don't talk about Stalin or Mao or any of the other horrible people. I think it was Mao. Did I get that name right? See, that's where I question myself all the time. You read pencils without the C? See, you say Marx, and my mind went to 80s music. Richard Marx. Hey, don't talk about what's wrong? Billy the Kid. Okay. One, Young Guns is great. Love that movie. Oh, you might be calling me a nerd. I have no idea. Number 2, Billy the Kid off of, I think it's MGM now. Maybe it used to be Stars. Good series. But this is where my mind goes. I asked my husband, I said, if Billy the Kid and Pat, whatever his name is, and all the people that were involved, if they could see all the things on all the shows and all the things that have been done to talk about them, like what happened, did this guy really, the heck was his last name? Garrett. Thank you, Snipe. Did he really, take him out, or was he still alive, like Young Guns 2 showed? Or is all this just so far off base? Because in Billy the Kid, the series, he's a good guy. So, like, if I could have a conversation with Billy the Kid without worrying about if he was going to off me or not, it would be, I would want to know. Who are you? Were you the bad guy? Were you the good guy? Were you in between? Were you both? Do you know all these shows? Are you a ghost? I'm just kidding. But inquiry minds. My mind goes weird places. Would I want to talk to Al Capone? There's probably, probably not. I like the true mafia movies. I like those. There are probably some people in there that I would pick before I picked him, but I can't name them, so don't ask me to. They don't talk about Gorlock, Destroyer of Worlds. What? Is it Genghis? Wait, what? Oh yeah, but the Mafia doesn't exist, so those are not true movies. True. Thank you for pointing that out before I got a visit. Just open my door and there'd be broken pasta all over it, and I would just know I was in trouble. I would be like, crap. Also, I'd ask Gabby where she was hiding in my woods. Okay, we did it. I think we're through the worst of it. We are almost done with this thing. We'll get the verdict tomorrow. We can do it. We can do it. Thank you guys for hanging with me through this, because I know it's been a struggle for a lot of you, and I do appreciate it, and I appreciate everyone's input. So I like all the discussion, because it's made me think a lot. I have probably thought more about this one than a lot of them. And no, I don't think Betty Broderick and Sarah Boone are even closely related at all, Flash fan. Other than their level of, they're both kind of crazy. That's true. Gabby would not break the pasta. She would dump. I don't have any pre-broke. Oh yes, she would dump your pre-broken pasta in your bed. You said something about Sarah. Somebody said Sarah Boone and Betty Broderick were closely related, closely like whatever. You said something about that, but I don't think they're the same at all. I agree, whoever. It is a very useful thing to discuss. And it has been more challenging than other cases. But thank you. All right, guys. I will see you tomorrow. I think Miss Gabby may be here. We shall see. And, nope. Rocking horse head in your bed. You'll have to tell Flash fan your Sarah Boone joke. Snipe. He doesn't forget about old Sarah Boone. At a certain point, what's more important is to discuss how people end up staying in these things. True. And I just always hope they get out, Jenny. Thank you, Heidel. That's the thing. Like, all this is obviously still happening today. Like I've said, I hope the laws have changed. I think they have. For the better, for the most part, I hope. So, okay, I'll tell you tomorrow, because I'll have a better idea tomorrow. So, I'm just gonna end it. I'm landing the plane. Here we go. I'll see you guys tomorrow. Have a great rest of your night. Go take some deep breaths or walk outside. Do something to clear your mind of all that we just heard, and yes, life is good. And I will see you guys all tomorrow.
Hot mannequin love is kinda uncanny. Click, like, subscribe, ooh, piece of candy. Looking for my spotlight, chasing my vibe. Still looking for my credibility online. Ooh, hot mannequin love, candy on the floor, don't pick it up. Chasing all the clicks, chasing all the views. Credibility's hiding, but I'm bringing you the news. Every little scroll is a mystery, but you stuck around, watch the show with me. Laughs and chaos, that's how we roll. Drop a comment down below before you go. Every little scroll is a mystery, but you stuck around, watch the show with me. Laughs and chaos, that's how we roll. Drop a comment down below before you go.